we're now going to start a series of presentations about what it means to be an academic and to research competition law, and we wanted to bridge between what we do, academics, and what enforcers actually do when they, or if they do rely on economic and academic evidence. For that, I'm extremely pleased to have you, Henri. I think you have I told you already, one of the most unique profiles because you worked in private, in public, you had different roles. So I'll make it quick, but you are currently an advisor at the European Commission DG Comp, working in the Foreign Subsidies Unit. You previously were the vice president of the French competition agency, the Autorité de la Concurrence. You've been in the space for over 25 years. You've been working at DG Comp before rejoining DG Comp. You worked on pharma, digital, energy, telecom, merger reviews. Something I didn't know. You have to confirm whether or not this is true. You hold a degrees in engineering. Yeah. Okay. Political science and economics. And you were what was the title? Research fellow at Harvard University from 16 to 17. Again, I'm extremely pleased to have you. You were already kind enough to do some guest lectures for me back in the day. So very curious to what you have to say. The instruction, to be clear, was for you to tell us about whether you consider academic and our research as being relevant. If so, how? How could we engage with you? So the floor is yours. Thank you very much.
Thanks very much. So I scribbled some things, but my writing is really bad, so I don't know whether I'll manage to read what I've written. I should have done some slides, but voila. It's the way it is. It's really an honor for me to, and a bit humbling, I must say, to speak before you, because I'm probably the only one here not having studied law, and I did study a little bit of economics, but not so much. So I'm very much what you would call in French un dilettante, un touche-à-tout. So I tend to not to go very deep, but to be interested in many different things. As Thibault was mentioning, I've done quite a few things in the competition policy world, being in private practice, or in research, or at the French Competition Authority, or at the Commission. But Thibault forgot one very important position that I'm still holding today. I surf, and to do surfing, I go to French Polynesia, to which I am a member of the board of the competition authority over there. And I will come back to that, it's important in terms of interaction with academics. So when I joined DG Competition, at the time it was called DG4 in the 90s, one of the first cases that I had to deal with was a payment system case, which had to do with Eurocheck. I mean, the youngsters don't know Eurocheck here, but let's say it was like Visa but with paper. And what was very interesting to that is that everybody was scratching their head as to how do you define a market there? Is there a market between the two banks, but they have agreed then on prices that they exchange when there is a payment? It doesn't make sense. So people were really turning into circle, trying to understand how these markets function. And it took a while, and it was really thanks to academics. I am referring here to the key paper of Tirol and Rocher in 2003, which for the first time set out, what would be the multi-sided kind of market and the kind of analysis in terms of competition policy also that should be applied to such markets. So imagine when I joined, it was 94, it was 9 years before that. I tried to find some, academic research that could shed some light on this kind of market, but it was really difficult. And I had some discussions with some economists or some lawyers in the US because they were a bit more advanced than we were. But still, it's only in 2003 when the theoretical framework was brought, and then it really opened the way to be able to better address such issues in multi-sided markets. I was also involved in the Microsoft case, which was mentioned this morning, decision of 2004. In that decision, there were two issues raised. One was about interoperability, that was mostly network effects. Network effects was an outcome of research in the 90s. But there was also the media player, which is a complicated case, but a case that relies, again, on multi-sided markets and this kind of effects. Moving forward, in the early 10s, I was involved in Piffaut delay cases and in how to apply antitrust to the pharma industry. Here again, there was a really big tension between intellectual property and the application or applicability of competition law to these kind of markets. Where do you draw the line? And here again, it was really helpful to be able to interact with academia, and here it was more on the legal side, on how to draw such a line in pay for delay cases. And I remember very well, back in, I think it was in 2014 or 2013, there were a bunch of economists who came to present a empirical paper on killer acquisitions in pharma. And that really opened our eyes. Oh, there's an issue here that we hadn't realized. The key assets could be bought by competitors in order to kill potential competition. We should look at that. And you know what happened later in other fields than just pharma. So all of that was just a long introduction, sorry, just to explain to what extent really, in a way, research matters to me. When I was asked by Thibaut to think and to present about all these issues, I was thinking, so how could I conceptualize the interaction between enforcement and research? And I was thinking, yeah, well, in a way, research can inform at three different levels of competition policy. So, are we looking at the right issues? Here, for instance, killer acquisitions. Before that paper, that's not really something that we actually dealt with, or we actually dealt with in the Servier case, to be honest, decision 2013. But that was something which was a little bit out of our spectrum. But for instance, when you look at the digital markets, again, multi-sided platforms, the way that we were looking at them before the string, or also including the string of decisions of Google decisions, in a way we were not applying exactly the right law, or not inventing the right law, in order to address the issues raised by big tech. So, and there again, there was a lot of academic research, and I think the Commission did something very good, but a bit late. We asked three academic experts to produce a report on how to address the new challenges raised into the digital industry. So that was a report issued in 2019. It took 2 years to actually write it, and it was written by three academics. One was an economist, Jacques Kremer from Toulouse. Another one was a IT guy, Yves-Alexandre de Montjoie, who will soon be the first CTO at DG Competition. And the third one was a lawyer, or a legal academic, Heike Schweitzer. And I remember very well Heike mentioning the skating union cases and saying, well, probably that's the way to look at the platforms. In a way, platforms are regulators, profit maximizing regulators. And I think she was really right. So, first point was to what extent academia can inform whether we are looking at the right issues. The second point would be, do we use the right means? So, for instance, sorry, I forgot to breathe. Do we use the right means? For instance, what kind of test should we apply? Should it be a kind of per se test? Should it be a by-object test? Should it be a by-effect test? And here there's lots of literature which has been developed and can inform us. I mean, we were speaking about RPM earlier on. So in the US, there has been a big argument that was settled recently by the Supreme Court on whether it should be, some kind of structured rule of reason or per se prohibition. Well, it doesn't matter because California has a per se prohibition of RPM, but still there's a movement in the kind of test that should be applied, because academics were arguing, well, you are creating a rule which has an error cost which is too high with a per se prohibition. Thibaut was mentioning that I'm working on the FSR, so the Foreign Subsidies Regulation. Here we have to invent everything. So we are in the process of publishing guidelines on how we will apply such new tools in finding distortions, for instance. But that raises really interesting concepts. What kind of tests are we going to apply to find a distortion? Is it a capability test, which is equivalent to the one that you find for 102? Or is it something different? Should we put the bar very high or very low? And all of that has been informed by interaction with academia, for instance. Or should we apply such tests at the time that a foreign subsidy is granted or becomes beneficial, or should we apply it ex post after having seen the effects? Again, that's something which is very much informed by the academia. Now moving on to how academia can help us, and we should interact with them, is to assess whether we are doing the right job. So, right objectives, right means, but ex post evaluation is also very important. And here, that's mostly about economics, developing the right tools to do ex post evaluation and to assess whether, we did the right thing on the right cases, or whether we are applying the right test on the right kind of behaviors, for instance, or right kind of mergers. But it should also involve academia. There's not much work which has been going on. We have tried at DigiCom to develop that for the past few years. There was a big report published, I think in 2024 on that. But there's lots of work to be done. So that's all I have to say about the interaction between academia and us. Now, how? If I were sitting on the, where you are sitting, I would really be eager to work with the Commission, for instance, or any competition authority, because there is so much data there. And when I say data, it's not just economic data, but it's also all the internal notes on how people have legally analyzed the various cases that they have been dealing with, and when they decided, not to investigate this kind of behavior, this kind of merger, this kind of state aid or whatever, and when they decided to investigate. All of that exists, but obviously cannot be available, and that's very frustrating. In turning back to VFSR, we have to produce some kind of review at in mid-July, the 14th of July, which is an easy date to remember, at least for a French guy. We have to produce a review of the first few years of implementation of that regulation. And to do that, we have asked a consultancy, helped by an academic, to review actually what we have been producing and to produce some kind of opinion. And I think if I were the academic in question, I would be very happy to be doing that, because that's really a special access. So that's one kind of interaction that we can have with academics. Another kind that I experience quite often is that I receive an email, from an academic saying, I'm writing a postdoctoral kind of paper on this issue, let's say the influence of Chinese investment in Europe. Can I interview you? And would you have suggestions as to who else to interview? That's always very enlightening in a way, because when you have a conversation with such people, they come with their own perspective, which is phrased into their questions, but you understand where they're coming from. And then also you can ask about, what they have heard from other stakeholders. So I really enjoy the fact that, research today is much more in interaction with enforcers and policymakers, and more generally with stakeholders. Because, both sides, all the sides benefit out of that. Now, when you're conducting research, how can it be useful in general to enforcers? I produced my taxonomy of kind of research that is helpful already earlier today, but let's say that the more conceptual it is, in a way, the less interesting it is, and the more it is empirical, and it looks at actual facts or actual developments or actual issues, the more it is interesting. And how can you come and interact with enforcers? It's very easy. Usually, if you contact people at, say, DG Competition or even French Competition Authority or elsewhere, you would find an open door to come and present a paper that you have just published, and where people can interact with you and ask questions on your main findings. Now, to perhaps one last remark before concluding, and the last remark is again about French Polynesia. So why do I come back to surfing? Well, it's because when you think of it, competition law shouldn't be applied in the same way if it's in Europe, a market of 450 million consumers, compared to French Polynesia, where there are 300,000 people scattered on 65 islands. You cannot apply the same rules with the same level of demand in a way, and the same level of scrutiny. So you have to develop a kind of dedicated competition law, or dedicated kind of system of finding and tests, etc. And for that you need not just the crazy mind of high-flying enforcers. You need people who make research, who think about it. And what's the cost benefit? I mean, in terms of cost benefit, in terms of error cost, what kind of tests, what kind of law are you going to develop that's going to be helpful and useful to the Polynesians or to small islands? So we over there, we have tried to build a kind of network between competition authorities of small, isolated territories, mostly islands, but not only, to try to share experience and to involve also academics from the region into that network, so that they could inform with their own research on how to adapt competition policy and competition enforcement to that. Now, conclusion. Is it worth, I mean, in what sense would it be worth for a researcher, let's say somebody who has just done a PhD, to come and work in a competition authority, or to come and work at DG competition? I think it can be very, very helpful, but you should always remind yourself that the work that you do in a competition authority is much more enforcement oriented, and in a way less conceptual. I like concepts. I'm very much a French guy in that sense, but sometimes you have to apply the concepts. Otherwise, it's worthless to have thought about concepts. So think twice if you have a PhD and you want to engage into a competition authority. I mean, at least on the legal side. On the economic side, there's always something to be done. At least if you have some empirical leanings. Think twice, because you may have some very interesting and cutting-edge issues to decide upon or to contribute to, like in the FSR, what we have been doing. But then you have to put your hands into le cambouis, as we say in French, into the dirty earth, and you have to build something. Thank you very much.